Not under that city.
Not from the state.
Let me get this pulled up. In addition to that, I did receive a short few statements in writing from Mr. Guillory. Did you get an opportunity to review that as well? I have an extra here if y'all want.
I have copies.
Okay. Mr. Kimler, if you want that.
I saw.
Okay. And so Mr. Guillory is on probation, a deferred probation from June 26th of 2024 for the offense of unlawful possession of a firearm by a felon. And Mr. Coleman, does the state have witnesses with regard to proving up any of the other allegations in that motion?
We do that.
You may proceed and call your first witness.
We invoke the rule.
I'm sorry?
We invoke the rule, you know.
All right, so would anybody that is going to testify in this hearing please come forward so I can swear you in? And would you please print off the MTRP for me that I made notes on already? That's good. Would y'all please raise your right hand? Do you and each of you solemnly swear or affirm that in the hearing today, your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. So the rule has been invoked, and so I'll ask you all to please step outside other than the first witness. Mr. Coleman?
That'll be Elizabeth Chelsea May Allen.
Is that you, Miss Allen? You can come on up and have a seat. Yes, ma'am. If you'll just make sure you speak loudly and clearly into that microphone so we can all hear you.
Can you hear me?
That's perfect.
That's perfect.
Yes, ma'am. And also, if it's a yes or a no question, be sure to say yes or no, not just an uh-huh or a head nod so the court reporter can take everything down.
Yes, ma'am.
Thank you. Mr. Coleman, you may proceed.
Thank you, Your Honor. Thank you for being here this afternoon, Ms. Allen. Would you please state your full name for the court reporter?
Yes, ma'am. I'm sorry. Yes, sir. My name is Chelsea May Allen.
And Ms. Allen, where do you reside? I don't need the address, but just the city and state.
Salisbury, Texas.
And I guess it does matter for purposes of this hearing, specifically where you were residing back on June the 8th of 2025. Were you living at 4547 FM 1003 South in trailer number 5 in
Yes.
Quincy, Texas?
Yes, sir.
And that's in Hardin County, Texas?
Yes, sir.
And was one of your neighbors the defendant in this case, a Leonard Guillory?
Yes, sir.
And do you see that individual, your neighbor at the time, in the courtroom here today?
Yes, sir.
I'd ask that you point to him and identify him by an article of clothing that he's wearing, please.
In the orange jumpsuit.
Your Honor, I ask that the record reflect the witnesses identify the defendant.
The record will so reflect.
On that particular day, did you call the police?
Yes, sir.
For what reason?
It was witnessed that he was trying to get into my car, so I did call the cops
I'm
and
gonna object to
report.
the responsiveness of the questions. She said, she phrased it, it was witnessed. Did she witness it or was it?
Let me clarify.
Sustained. Thank you.
Clarify that. Did you witness him do these things?
I witnessed the end of it, not the beginning of it.
Let's tell the court what you witnessed at the end. What did you see? What did you see with your own eyes?
Yes, sir. When I was told that someone was breaking into my car, I went out onto the front porch and I saw him getting out of the vehicle.
Getting out of whose vehicle?
My vehicle.
Did you in any way give him permission to get or go inside of your vehicle?
No, sir.
Had you ever given him permission to go inside your vehicle?
No, sir.
How would you characterize his demeanor that day?
He seemed off. I mean, I really didn't know him that well. They were new to the neighborhood and stuff, but I didn't know him. I really never knew any of my neighbors, so. But he didn't seem like himself at all that day.
And as a result of what happened, did the police show up?
Yes, sir.
And if you witnessed this, did you see him get arrested by the police?
I didn't see him get arrested, but I did, they did have him in the car, and when I pressed the charges.
Okay, and just to be clear, back on June the 8th of 2025, this defendant, you saw him inside of your vehicle and you didn't give him permission to be in your vehicle?
Correct.
Now I'll pass the word.
Thank you. Mr. Kimler?
Yes, Your Honor. Morning. What kind of vehicle was it?
2000 Chevy Blazer.
What color?
It's a blackish blue.
How long you had it?
A few years. I want to, well, a year and a half to 2.
Was it your custom or practice to lock it when you weren't in it? When you had it parked at your residence?
No, it was not locked.
Why not? Did the lock work? Or
Yeah, the locks on my vehicle work, yes. It just, in that neighborhood, we felt, all of us neighbors felt safe enough that we didn't need to lock our vehicles right when we got home.
Okay. Was your vehicle damaged in any way?
Not that I could see.
So the window wasn't broken out or anything?
No, sir.
What was taken out of it?
Nothing was taken out of it, at all. It just looked like he got into our vehicle, like my vehicle, and, you know, if it's not your vehicle, there's no reason for you to be.
Right, sure, and I get mad about that
Yeah.
too, if it were my vehicle. But was there anything laying around in your vehicle? I mean, do you keep change in the cup holder, or
No, sir.
was like anything of value that could have been taken?
No, sir, not in the vehicle.
What about other stuff, just maybe stupid stuff that could have been taken?
Asking that.
No, sir.
Well, nothing of value, but there could be other things that could have been taken.
There was nothing in the vehicle that would have been taken.
So you keep a very neat vehicle and tidy and all that,
Objection, Bill.
For the most part.
Sustained. What's the relevance?
to show that he didn't intend to commit this burglary of the vehicle. He has to have the intent to commit theft or be a burglar. Just because he got out of the vehicle doesn't mean it's a burglary.
Go ahead.
That's all I have. Well, let me ask you this, you don't know what kind of vehicle Mr. Gilby drives or anything?
Not that he drove, no.
That's what,
Any other questions?
Just a follow-up, Judge. Ms. Allen, did he attempt to start your vehicle?
From what I was told, yes.
objection here, so that's what she was told, Your Honor.
Sustained.
Wait, can I ask her, do you leave your keys in the vehicle?
No.
So how would he have tried to start the vehicle if the keys weren't in there?
It looked like he was trying to get under the steering wheel and maybe try to jump, like started with wires, I don't know.
Well, did you observe any damage to the vehicle, like underneath the steering wheel?
Yeah, I checked it, nothing from my eye looked like it was tampered with, but we also caught him in the moment that it was also happening, like it was right off the back, right out the kitchen window, we saw him get into the car and he, I was told, and then I went outside and told him to get out the car.
I don't wanna know what you were told, just what did you observe? Let's just be clear for the judge, what did you observe? You personally see.
Him get out my car.
I thought, did you look out the window and saw him get in it? or
No, I came out the front door and saw him get out my car.
So you never saw him get into the vehicle?
No,
I thought you said you looked out of your kitchen window and saw him get.
I said a witness saw.
Oh, okay, not you.
No, I saw him get out my vehicle though.
Okay. That's what it is.
Nothing further for this witness, may she be excused, Judge.
Yeah, any objection to that?
Nothing.
Thank you, ma'am. You're excused.
Your Honor, the state calls Deputy Devin Campbell.
Sure. What was the name? I'm sorry.
Devin Campbell.
Thanks. Yes, sir, right there. Thank you, sir. If you'll just pull that microphone, make sure we can all hear you.
Good morning, Deputy Campbell. Would you please state your full name for the court reporter and spell it, please?
DEVANCAMPBE12.
And Deputy Campbell, if I can make sure that, get you to speak up, I want to make sure the court can hear everything you have to say. Back on June the 8th of 2025, were you working for the Hardin County Sheriff's Department?
Yes, sir.
Were you dispatched out to 4547 FM 1003 South that day?
Yes, sir.
And what was the nature of that call?
It had initially come in as they categorized it as a problem with neighbors, but the initial complaint was that someone was trying to steal their vehicle.
And once you arrived on scene, did you make contact with the subject or a suspect?
Yes, sir.
Did you make a determination based on your contact with that subject as to, and talking to the witnesses there on scene as to whether or not this individual should be arrested?
Yes, sir.
Did you arrest this individual?
Yes, sir.
Did you identify this individual?
Yes, sir.
What method did you use to identify the individual?
His driver's license.
And who was he identified to be?
Be the Leonard Gilbert.
Leonard Gillett.
Yes, sir.
What, if any, other observations did you make of Leonard Guillory that day back on June the 8th of 2025?
He appeared to be intoxicated on something. He's reported to have been going around.
Objection, what he was reported, Your Honor, unless it was related to the initial dispatch, I think.
His words were he appeared in what he observed.
He said it was reported.
After he said he appeared to be intoxicated, then he went further, so that's sustained with regard to that point.
What demeanor or characteristics did you personally observe in this defendant?
He appeared to be very sluggish to respond to any questions I was asking him regarding his involvement in anything. But he was just looking straight through me like he was not having an out-of-body experience or just not there at the time.
Very good. Did you prepare a report detailing your involvement in this case?
Yes, sir.
Did you review it prior to testifying here today?
Yes, sir.
Your Honor, I pass rules.
Thank you. Mr. Kimler?
You submit the report to the county attorney's office?
Yes, sir.
You know if they picked up the case yet or not, or the status?
No, sir, I'm not sure.
Could you spell any odor alcoholic beverage,
No, sir.
so we could rule out alcohol when you were indicating he seemed to be in some sort of altered state?
Potentially.
I
I'm
mean,
not
you
sure
didn't
what
detect
it is.
alcohol, right? You didn't smell it?
No, sir.
That's what it is.
Nothing further for Deputy Campbell. May he be excused, Judge.
Any objection?
Okay.
Thank you, Deputy, you're excused.
At this time, the state calls Officer J.D. Cross.
Officer Cross,
Officer Cross.
thank you. You can have a seat, sir. You may proceed.
Thank you, Your Honor. Officer Cross, would you please state your full name for the court reporter?
John Cross.
All right, and Officer Cross, you're obviously in uniform. You work for BPD, correct?
Yes, sir.
We worked for BPD back on June the 19th of 2025.
Yes.
Did you receive a dispatch to a park that afternoon, or that day, I should say,
Yes.
or in the area of the park? What were you dispatched to as it relates to this case?
So we were finishing up an unrelated shooting investigation at Roberts Park when I wasn't necessarily personally dispatched to it, but over the police radio, I heard other officers being sent to Shoshone Park, which is about 5 or 6 blocks away, in reference to another aggravated assault incident.
And what did you do after hearing that? And let me back up.
Yes, sir.
Shoshone Park, that's at 1305 Harriet in Beaumont, Texas, correct?
Yes, the right at the corner of Shoshone and Harriet.
And that's in Jefferson County.
Yes, sir.
All right, what did you do?
So me and my partner at the time were in the area, and Lieutenant Slider got on the radio and said, hey, a guy matching the description of the suspect in the Shoshone Park call just rode his bicycle past my location at Roberts Park, which we just left from the shooting investigation a few minutes prior.
And then what'd you do next?
We were the closest marked unit there, so we turned around and went back to the area of Roberts Park on the Avenue C side, on the west side of the park, I believe.
And what, if anything, did you observe?
I observed person I know through previous law enforcement contacts to be Leonard Guillory. riding his bicycle, and we were traveling northbound on Avenue C. And, he was traveling southbound on the bicycle. We were in a fully marked black and white, Belmont Police Department police patrol vehicle. I activated the, red and blue emergency lighting equipment and, positioned the vehicle in front of Mr. Guillory.
And what did he do next?
He did not stop. He, rode the bicycle into like a vacant lot on the corner and kind of circled through the lot and took off, westbound on Roberts Avenue.
Did he take off on the bike or on foot?
On the bike initially, and, about midway down the block on Roberts, he got off the bike and, began running on foot through some backyards.
And did you form an opinion as to whether or not this defendant was actively evading your arrest or detention of him?
Yes, sir. Yes, sir. To me, it was very clearly met the, elements of the offense of evading detention.
And just to be clear, you encountered this suspect matching the description in the area where a aggravated assault had been reported with a firearm.
Yes, sir.
Were you able to eventually capture or detain the defendant?
Yes, sir.
And you mentioned having prior contact with him. I'm not gonna go into that right now, but
Yes, sir.
do you see the individual in the courtroom here today that you arrested back on June the 19th of 2025, and that you know to be Leonard Guillory?
Yes, sir.
Would you please point to him and identify him by an article of clothing that he's wearing?
He's, so right there wearing the orange jumpsuit.
Thank you, Your Honor. Pass Williams.
Thank you. Mr. Kimler?
Yes, ma'am. What time of day was it?
This was, daylight hours, but later in the afternoon.
What
I
month,
could,
what month was it?
it was in June.
Hot,
Yes, sir.
very hot, right? You're on routine patrol? Or what were you doing when you heard the radio chatter?
We had just finished the, shooting investigation.
So that you gone back on call?
Yes, sir.
So you were on routine patrol after that, responding to radio traffic? And you said you investigated a shooting?
Yes, sir.
Said shot, what part?
Roberts Park.
Roberts. Where is Roberts Park in relation with Avenue C?
It's on Avenue C.
Okay.
It's bordered by Avenue C to the west, Avenue B to the east, Roberts to the north, and Prairie to the south, I believe.
Alright. So you return to duty, leave Roberts Park, is that right?
Yes.
How far do you go from Roberts Park before you get the call from Slager to do something?
I'm not sure, not sure.
To be clear, on the investigation of the shooting, you hadn't identified a suspect, is that right?
On the initial shooting,
Right.
yes, the suspect was already in custody for that.
Okay. So we can rule out Mr. Guillory is responsible for that shooting, is that correct? Since you had a suspect in custody?
Yes, sir, as far as I'm aware, I don't think he was ever,
Suspected or detained or arrested or anything in relation to that shooting, is that right?
correct. It was an unrelated aggravated assault that occurred at the same time we were finishing that investigation
And where did this alleged aggravated assault was alleged to occur?
at Shoshone Park.
And where is Shoshone Park?
At 1305 Harriet, at the corner of Harriet and Shoshone.
Harriet Shoshone? And how far is that park from Roberts Park?
It's about 5 or 6 blocks south of Roberts Park,
Did you say 5 or 6 blocks would be about a mile perhaps, or less than a mile?
less than a mile.
Quarter mile, half mile? Quarter mile?
I mean, I'd be guessing.
Less than a mile. You're comfortable with that?
Yeah, I mean, I can pull up a map
I'm
that's
just asking you what you're comfortable with as far as this.
less than a mile.
Less than a mile. So, did you proceed to Shoshone Park or not?
No,
What did you do?
as we left the shooting at Roberts Park, two calls, the aggravated assault call that Shoshone Park dropped. At the same time, we heard gunshots, a few blocks to our west. So we checked a few blocks to the west for the gunshots, and then we're heading back over to, Shoshone Park
From what direction?
from the west.
So down Avenue C?
No, Avenue C goes north and south.
So you're heading back over to Shoshone Park from the west, is that right?
Yes, sir, we're coming eastbound on Washington from probably like Avenue E. So 2 blocks. to
And
the
did you
west.
eventually make it to Shoshone Park?
No,
Why not?
because before we could get there, Lieutenant Slider got on the radio and said he located who matched the suspect description on Avenue C.
Suspect from what description, what incident?
From Shoshone Park.
So Schleider wasn't at Roberts Park, he was at Shoshone.
He was,
Sir? He was at Shoshone Park,
yes, sir.
and he told you directly your unit or just in general?
He, on the police radio, he said, hey, I believe I've located this guy. He said the description, shirtless, black male with a green scarf or shirt around his neck, riding his bike. He said he just went, past him on Avenue C.
So why didn't Schleider stop him?
Sliger's in an unmarked car, and the detective, he's not wearing bulletproof vests. He doesn't have lights and sirens and stuff like that.
So did Schleider respond to the Shoshone Park incident or not?
I don't know.
Do you know where Schleider derived his description of a suspect, or how he derived this?
Which what dispatch forwards on the radio.
So you're unaware of who told Schleider, or gave Schleider the description of the person that you just described?
No, I just said that that's the description dispatch said on the radio.
I thought you said Schleider gave you the description. Did Schleider give you the description, or did somebody else give you the description of the person?
What I said was that dispatch gave the description, Slider got on the radio and said, hey, the guy matching that description is driving past.
So Schleider evidently heard the same transmission you did, right?
Evidently.
And said, hey, I just saw somebody that matched that description,
Mhm.
right?
Yes,
So we don't know who gave that description.
that was given by dispatch.
Right, to dispatch, you don't know who gave dispatch that description.
No.
The dispatch wasn't at Shoshone Park to witness it firsthand, right?
Correct.
So it had to be derivative then. Dispatch was derivative when dispatch gave you the description, they derived it from somebody else.
From a witness or complainant who told it.
We don't know, right? So Schleider says, I see a guy that matches the description dispatch just gave on Avenue C, so what did you do? You were the closest unit to Avenue C,
Yes, sir.
and you proceeded to Avenue C,
Yes, sir.
and you saw an individual that matched the description,
Yes, sir.
confirmed what Schleider told you,
Yes, sir.
and that individual was riding southbound on Avenue C,
Yes.
and at that time, how far was that distance from Shoshone Park where you first saw the person that matched the description of her dispatch?
Right there, is either at the corner of the park or 1 block away from the park.
That would
It was
be,
right there by the park.
I thought you said that was Roberts Park that was on Avenue C. So it was Roberts Park or Shoshone Park? How close was,
Oh, how close was I to
Object to the
Shoshone?
compound nature of the question.
Here, let me just stop you, Mr. Kimmler. I'm lost
I was-
right now, so you're going back and forth. You're putting words, I think, and using the two parks to where I'm not sure. So I felt like I was, but I'm not anymore.
I was about to, that was what I'm trying to clear up is how far was that individual at the table, Mr. Guillory,
Yes.
when you first saw him from the location on Shoshone Park where the alleged aggravated assault occurred, when you first saw him? How far away from Shoshone Park
Oh,
was it?
that's from Shoshone Park.
Right.
That's same distance as I said 2 or 3 times before, I think 5 or 6 blocks.
Okay, so there, evidently, whatever incident there was at Shoshone Park, when you first saw Mr. Guillory, he was 5 or 6 blocks away from there, is that right?
Yes, sir.
So he was coming towards your vehicle, is that right?
Yes, sir.
And you initiated your overhead lights and got on the speaker and told him to stop?
I don't recall if I got on a speaker and told him to stop, but the lights were initiated.
How far away was Mr. Guillory when you initiated your overhead lights?
I don't know the distance he was when I turned the lights on, but he rode the bicycle right up to the hood of the patrol car and drove around it, or rode around it.
Drove around it? Drove
No.
around the car?
Drove, however you want to phrase
Did
it.
you indicate to him that he was being stopped or detained?
That's generally what red and blue lights on a police car mean.
Well, if you're on a bicycle riding down the road facing the vehicle, I mean, it may be some ambiguity in your intentions with the lights.
Not through my experience stopping hundreds of bicyclists and pedestrians.
Did you get on your loudspeaker, your public address system
I
and say
don't
stop?
recall.
You don't remember?
Mm-mm.
So this wasn't just a consensual encounter between Mr. Guillory and you?
No,
You have reason to think that he may have been reasonably interpreted this to be some sort of consensual encounter between him and law enforcement that he chose not
I
to?
object to the speculation as to what this defendant may have thought.
I think he
Sus-
can answer if he knows or not.
Sustained. It's not helping me.
People have a right to terminate consensual encounter with law enforcement, is that right?
correct.
How is a person supposed to know when it's not a consensual encounter?
Well, generally during a consensual encounter, you wouldn't activate your lights. You wouldn't be chasing a person.
Well, let's say,
Consensual encounter would be like I walk up to you and say, hey, my name's John, what's your name? And I shake your hand like a normal, like, conversation or interaction.
so he rode his bicycle around your vehicle and then basically, according to you, he evaded, is that right?
Yes, sir.
And he didn't have a shirt on, right?
Correct.
And what kind of firearm did you recover from him?
I recovered firearm.
So wasn't there supposed to have been a shooting at Shoshone Park?
No,
Waving the firearm around?
I believe that's what the reporter incident was.
So there's supposed to be a firearm involved some way at Shoshone Park?
Yes, sir.
Did you ever see Mr. Guillory discard a firearm?
Be sure to say yes or no for the
No.
court reporter.
Do you have any clothing on that maybe he could have concealed a firearm?
Yes, sir. He had some baggy pants or shorts on
And you searched him, right?
when he was eventually arrested. Yes.
Did you go back, or did you maintain a visual on him the entire time you allegedly evaded?
Be sure to say yes or no.
No.
So you went back and searched the path that he followed with the intention to evade to make sure a firearm wasn't discarded?
Yes.
And no firearm was discovered, is that
Not
right?
at that time.
Well, anytime. Was one ever recovered?
Yes, sir. I believe I was informed, later on, a few days later, that, another shift had been dispatched out there to that area, and someone had called in and said, hey, I found a gun in my trash can or something.
Well, do you know if that was along the path that Mr. Guillory evaded or not?
That's all I have is that little bit of third-party info. I can't speculate. I don't know. You have to talk to the officer who went out there and did that. I know it was in the general area.
So we can agree that's speculation then, that,
It's speculation from me.
all right. Well, at this time, it's speculation, right? Is there anything else that would indicate?
Mr. Kimler,
Ma'am?
you're asking the same thing. He said it's speculation. He said what he knew, where it came from.
He indicated it was speculation from him. I just want to confirm there's no other evidence that's before us that would indicate that it's anything other than speculation.
He answered that.
As long as the court's satisfied.
I am, thank you.
What was his mental state when you arrested him?
I'm not a doctor.
Did he appear to be intoxicated? Did he appear to be coherent?
Judge, I object to the compound question. He
Ask
asked
him.
one question after the other without letting him answer.
Coherent, did he appear to be coherent or intoxicated? You got a body cam,
Yes, sir.
bring it with you?
It's right here.
No, the tape, the video of
The
Mr.
video's in the cloud.
Okay, do we have it
It's not on
available?
like a cassette tape or anything.
Do we have it available to show the court or not? You don't know?
I don't know.
Did they ask you to make it accessible, or do you know? Do you know?
No, I wasn't asked.
Okay. He didn't resist arrest?
No.
What did you do after you arrested?
I went to the police station, completed my paperwork.
What did you do with Mr. Gilroy?
Another officer took custody of him and transported him to jail
From the scene where you,
where he was arrested in the, on like Avenue T, I think, in the back of the tool shed.
okay. And that ended your involvement then, from that point on?
Yes, sir.
Pass with us.
Mr. Coleman?
Yes, sir. Officer Cross, I know it's been a while since you had involvement in this case. I'd like to direct your attention, if I may approach the witness.
Yes.
To a couple of lines in your report, sir.
Yes.
I'd ask you to review those lines just really quickly there.
You want me to read it out loud?
No, just
or-
refresh your recollection if you don't mind. Specifically those highlighted portions.
Okay.
All right, does that refresh your recollection?
Yes, sir.
All right.
That's what I remembered.
Okay, as part of your investigation that day, was a perimeter set up?
Yes,
And was a K-9 unit or K-9 officer utilized to track the defendant?
yes, sir.
And this defendant was located at a residence or in the backyard of a residence located at 2680 Avenue D.
Yes.
In fact, some residents flagged you down. or
Flash
flagged
some
officers-
lead.
I'm just trying to get to it, Judge, I won't leave.
Thank you.
Witnesses, civilian witnesses were involved, correct? At or near that location?
Yes, do I have to just say yes or no, or can I explain?
You can explain.
While we were on the K-9 track, some citizens, kind of gathered our attention and were pointing. I don't speak Spanish, they only spoke Spanish, but another officer there, was a native Spanish speaker, and he said, hey, these guys are telling us that someone ran through their backyard a little bit ago, just took off running through. So Officer Guardian advised us of that, and that was the path we were following with the K-9 at the time. So we came to the tool shed in the backyard, and it was obvious that it was locked from the inside, right, like a hook and hasp kind of thing, you know what I'm talking about?
Yes, sir.
And so the residents gave Officer Guardian permission. He went back and talked to him. They said, hey, yeah, someone might be in that shed. If it's locked from the inside, you can go in there.
And was the defendant located in that shed?
Yes, sir.
Just by way of summary, the K-9 unit tracked the defendant to the shed that was located at the back of 2680 Avenue D.
Yes, sir.
And if a firearm was found in that same backyard 3 days later, would it be possible that the defendant discarded that firearm in that backyard prior to entering that shed?
I'm gonna object to exceeding less personal knowledge.
I'm just asking.
Overruled.
Yeah, and in your
If it's
conversation
possible.
and experience, would it be possible for someone, particularly this defendant, to have discarded a firearm prior to entering that shed at 2680 Avenue D?
I think it's possible. It's definitely not the first time in my career that it's been encountered where a firearm is discovered a few days later and then leading to something where it wasn't found at the time.
Very good, absolutely.
So you have personal knowledge a firearm was found in that backyard?
I know a firearm was found in the general area.
In the backyard?
In the general area. I don't know if that's the backyard, the front yard, the side yard.
And you don't know where a
maybe
firearm was
trash
found?
can,
Yeah,
correct.
right, you don't know where it was. That's what,
No other questions for Officer Cross, may he be excused.
Any objection?
I mean,
Thank you, officer, you're
All right,
excused.
thank you. Y'all have a good afternoon.
Thank you, you too. Mr. Coleman?
Your Honor, the state calls Officer Jasso.
Jasso?
Yes, Jasso.
Thank you. If you'll just kind of pull that microphone close, just make sure we can all hear you, and make sure if it's a yes or no question, to say yes or no, and not just a head nod or an uh-huh, so make the court reporter can get all that down.
Yes, ma'am.
Thanks, you may proceed.
Thank you, Your Honor. Officer Jesso, will you please state your full name for the court reporter?
First name's Jose, spelled Jose. Last name Hasso, Jasso.
Hasso.
Hasso.
I'll try to pronounce it correctly. You're obviously in uniform, you work for BPD. Were you working for BPD back on June 21st of 2025?
Yes, sir.
Were you dispatched out to a location at 2655 Avenue D?
Yes, sir.
What, if anything, did you locate at 2655 Avenue D?
It was a blacksmith in Wesson, 38 revolver, and the serial number for that was D935026.
And in fact, did a resident call dispatch or call the PD to report this firearm?
Yes, sir.
And this firearm, is it fair to say, was close, where it was located was in close proximity to the 2680 Avenue D? Is that fair to say?
I cannot say for certain.
We'll take a look at your report. Well, maybe you didn't put that in your report. All right, I would draw that question, fair enough. Let me ask it this way, though. If someone was running, in your common experience, through several backyards, to get to 2680, is it possible they may have run through 2655 to get to 2680 Avenue B?
That's a possibility.
And if someone had a firearm, in your common experience, that they wanted to discard before police encountered them, is it possible they may have tossed it in one of the yards leading up to the yard of 2680?
Yes, sir.
That's what.
Is that a high crime area?
Mr. Kibler, stand up and
Yes,
get,
ma'am, I'm more. Is that a high crime area? There's some shooting, calls for services.
Depends what you consider high crime.
What do you consider to be high crime?
Oh,
Well, you get a lot of shootings, or there, I say a lot, maybe a couple, 2 or 3 a month, maybe out there. How many would you say a month?
and then an exact block number, or where exactly are you referring to?
That block number in those areas, I say within, I don't know, quarter mile of that location where you found the firearm?
Yes, sir. I would say there's some.
Some, right?
I can't give an exact number, sir.
Is it unusual to find discarded firearms in that general area or not?
Can you repeat that?
Unusual to find discarded firearms in that area or not? Does it surprise you that you found a discarded firearm in that area?
No, sir.
And so you retrieved the firearm?
Yes, sir.
What did you do with it when you retrieved it?
I took custody of it and brought it down to the police department.
And before you did that, what did you do? Did you put it in a paper bag, or how did you transport it?
I don't recall exactly.
Okay, well, it's possible to lift DNA off a firearm, isn't it?
Yes, sir.
Did you preserve the firearm or take custody of the firearm in a manner consistent with perhaps later obtaining the DNA swab to see if it had, those epithelial cells or other DNA on it?
Yes, sir.
Do you know if it was submitted for DNA testing or not?
I do not recall.
Did you try to get any fingerprints off of it?
I did not personally do that.
All right, so you don't know. The responding officer on scene doesn't typically dust for prints. Did you make the request that it be dusted for prints or not?
I don't recall, but you're correct. We do not typically do the swab fingerprints. That's for our ID technician.
Right. So you don't know whether it was any prints or labels were trying to be lifted off of it or not?
Correct, I do not know.
Is that the sum total of your involvement in this case?
Repeat that again?
Sir,
Repeat that again?
is that the sum total of your involvement in this case?
Yes, sir.
That's what.
I have no further questions for this witness. May he be excused, Judge.
Any objection?
Go ahead.
Thank you, sir. You're excused.
Your Honor, the state's final witness is Joanne
Joanna, what's the last name?
Joseph with probation.
Okay. Good morning, afternoon. You may proceed.
Thank you, Your Honor. Would you please state your full name for the court reporter?
Joanna Joseph.
And Ms. Joseph, I'm not gonna go into your background. I'm sure the court's familiar with you and your employment with the Community Supervision and Corrections Department or Probation. What I will ask is whether or not you are or have been the supervising officer for this defendant while he's been on probation.
I have.
This defendant being Leonard Guillory.
Yes, sir.
And do you see the individual that you come to know to be Leonard Guillory through your supervision of him? Do you see him in the courtroom here today?
I do.
Would you please point to him and identify him by an article of clothing he's wearing?
He's right there wearing an orange jumpsuit.
I'm gonna ask that the record reflect the witnesses identify the defendant.
The record will reflect.
And what I'd like to do is just run through this really quickly. The fact that any defendant or offender who's placed on probation is made aware of his or her conditions of probation, correct?
Yes, sir.
It's a process by which you and other probation officers follow in each and every case, correct?
Yes, sir.
And are they also, in addition to being made aware of those conditions of probation, do they acknowledge those conditions of probation?
Yes, sir. They signed the back of the conditions of probation that states that they acknowledge they've received a copy
That's
and
what I'm
will
getting.
adhere to it.
That's what I'm getting at. And is there any reason to believe that that wasn't done in this particular case?
No, sir.
And in fact, just really quickly, a condition of his probation, like all other probationers, is not to violate any laws of the state of Texas or any jurisdiction, correct?
Yes, sir.
To report any arrest if he's arrested, correct?
Yes, sir.
Complete appropriately any community service restitution, correct?
Yes, sir.
Or I should say as directed. Obtain his GED, was that also a condition?
Yes, sir.
Not to possess any firearm, correct?
Yes, sir.
Complete moral recognition therapy, correct?
Yes, sir.
The defendant's already pled true to not paying his fees. Now, I'd like to shift and change gears to the defendant's arrest in Hardin County on June the 8th of 2025 for burglary of a vehicle. Did you come to find out about that arrest?
Yes, sir.
Did the defendant report that arrest to you as required by the conditions of his probation?
No, sir.
Did he, let's be clear for the court, is it a matter of him not timely reporting it, or did he not report it at all?
Both.
And what do you
During
mean?
an office visit, initially I asked this question of our probationers: have you had any interaction with law enforcement, drugs or alcohol? To which Mr. Guillory initially replied, no. We went through the office visit, and at the end I told him, I asked him about his interaction with law enforcement in Hardin County, and why didn't he tell me, and he stated that he didn't know what interaction meant. And then he got really upset and began to beg profusely, Miss Joseph, let me explain, and I didn't know. And so, that was when he acknowledged that he had actually been taken into custody and then started to plead whether he was innocent about the offense.
In this conversation about his arrest, if you recall, about how long was this after his arrest on June the 8th of 2025?
I don't really recall when. He rescheduled his, it would probably be around the 1st of July.
I see. In addition to failing to report the burglary of a vehicle arrest, where does the defendant stand as it relates to CSR?
He has not completed any CSR.
And he's been on probation, what, he went on back in June of 2024, is that correct?
Yes, sir.
And then since that time, no CSR.
No,
Where does the defendant stand as it relates to obtaining his GED?
he has not made any attempt.
Where does the defendant stand as it relates to attending and successfully completing moral recognition therapy?
He has not, paid for the book, so he has not even taken the, course.
The court has heard testimony from Officers Cross and Officer Jasso that would indicate this defendant very well may have possessed a firearm if the court believes that, and that he very well evaded from law enforcement if the court believes that testimony. Would evading arrest and or possessing a firearm be violations of his probation?
They would,
That's all I have, Judge. Afterwards.
Mr. Kimler, you may proceed.
How long have you supervised him?
I have supervised Mr. Guillory since his placement on probation in June of 2024.
Okay. When did he go into custody this last time, do you know? When did he go into custody?
I don't have a record of exactly when he went into custody.
Have you been visiting him out at the jail?
Yes, sir.
Are you familiar with how he's being, the medical treatment he's getting at the jail?
Am I familiar with the medical treatment?
Yes, ma'am.
No, I'm not advised of his medical treatment at the jail.
If I represent to you, he's receiving a monthly injection for schizophrenia and then daily oral doses of trazodone for antidepressant. Would that be inconsistent with anything that you know?
During a jail visit, Mr. Guillory told me that he had been off his medication, so.
But while at the jail, are you aware that that's what the regime
He
is?
has not advised me, and no one from the facility has contacted me to tell me that Mr. Guillory was being medicated.
Have you attempted to contact the clinicians or the medical practitioners?
I have not.
Are you a mental health caseload probation officer?
I am not.
Do you know if while on probation, there was any kind of referral for Mr. Guillory to MHMR or Spindle Top?
I did not make a referral, and Mr. Guillory, what he referenced, in the PSI and what I discussed with Mr. Guillory was childhood ADHD.
All right, but again, I'm going by what Mr. Guillory is representing to me as far as these two medications that he's being given at the jail.
Mhm.
There's no way to independently confirm that now, I suppose, other than having somebody from the jail to testify to that. But if he is receiving a monthly injection for schizophrenia and then the trazodone for antidepressant, do you think that untreated schizophrenia may have impacted his ability to comply with the conditions of probation as far as certainly the administrative things?
Yeah, I would object. The cost of speculation on the part of this witness.
Are you
Overruled, she can, if she knows or has knowledge of that.
untreated schizophrenia could affect that, is that right?
Perhaps.
I mean, You have probationers, I mean, are you familiar with the
She,
system?
she said perhaps, she's
Okay.
answered the question.
If he's treated, which evidently he is now being treated, and that treatment will continue through follow-up with MHMR, Spindletop, if he's released and put back on probation, do you think that he could be transferred to the mental health caseload and perhaps his performance on probation would improve?
That would call for objection, that would call for speculation again.
Overruled, she can answer it if she knows.
There is screening, there are procedures that one has to go through in order to be placed on a specialized mental health caseload. But, any person who's on probation, whether they're on, they don't have to be on a specialized mental health caseload, to, receive treatment.
Or referral to Spindletop,
They can go on their own.
right? And a regular probation officer could supervise them while they're being serviced by MHMR, is that correct?
Yeah.
As far as his demeanor or with you, is everything been appropriate, or has he been disrespectful, or have you made any observations that would, I guess, affect the judge's willingness to continue on probation as far as how he conducts himself personally?
With the exception of his, being disingenuous about his initial arrest, Mr. Guillory has always presented a respectful and an amicable disposition.
Absolutely.
Witnesses, Mr. Gillard, come on up, sir. Mr. Gillard, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down.
Proceed.
Give me just a second. Anna, would you also please text Kelly or call her to let Mr. Udishin know that it's going to be a few minutes, that it might even be closer to 12:45 or 1, but just hang tight. Go ahead.
Mr. Gary, you understand that we're in a hearing now, the judge is hearing evidence, and she's gonna make a determination whether to keep you on probation or revoke your probation and send you to the penitentiary. You understand that?
Yes, sir.
How long have you been in jail?
7 months.
During that 7-month period, have you undergone treatment at the infirmary back with medical personnel for psychiatric issues?
Yes, sir.
What is your treatment regimen now? What are they giving you? What's going on with your medication?
I'm receiving a shot every 30 days called Astraga, and I'm taking trazodone or about at nighttime, probably about 8 o'clock every night.
Has that helped you maintain your mental composure and coherence?
Yes, sir.
You heard evidence from a Hardin County deputy and a civilian witness about an incident where you were inside of a motor vehicle. Do you recall being inside that motor vehicle?
I remember the incident. I was off my medication. I got into the wrong vehicle.
Was it your intent to commit a theft?
No, sir.
What was going on when you got into the incorrect vehicle?
I thought that the vehicle was me and my fiance's vehicle. Just pulled the door. It was unlocked. I got into the vehicle, realized that it was our vehicle. Got out of the vehicle. A woman came outside and said, "Hey, what are you doing in my car?" And I told her it was a mistake. I was off my medication. I wasn't receiving my medication. I was going through a mental psychosis.
All right. You didn't have to force the door open or break the window. The door was open.
Oh, sir. Yes, sir.
Heard testimony from 2 BPD officers about an incident where you were on a bicycle. Do you recall that?
Yes, sir.
Tell the judge what happened as quickly as you can.
From what I remember, a police car came in front of me. I was riding a bike. I fell off the bike, hit my head. When I woke up, the police was around me asking me about a gun. Did I have a firearm? Did I possess a firearm? And they took me downtown.
Okay, were you involved in any incident in a park where anybody was assaulted, anything like that?
No, sir.
Did you have a gun on that occasion?
No, sir.
You know you have to stay away from guns, correct?
Yes, sir.
You try to do that?
Yes, sir. I do the best I can. I don't be around any firearms. just go to work for about a month maybe.
Passwords.
Judge, I have no questions for the defendant.
All right, thanks, you can step down. Okay,
Your Honor, if I may, I have very brief argument, just really brief. I
Yeah,
know
no,
it's very
that's-
quite a bit.
go ahead.
Judge, I remember putting this defendant on probation. It was a fact-specific reason for putting him on probation. You recall his criminal history, you may have his original PSI there in front of you. Ordinarily, I would never put somebody on probation who had a burglary of a habitation, who got revoked for 7 years, another burglary of a hab, looks like it ran concurrent, 7 years there, and a number of misdemeanor convictions. Ordinarily, I wouldn't do that, Judge, but I did went back, and I did go back and look at my file. The reason why I did that was because this defendant was found in a vehicle. The underlying case of the probation that we're here on today was found in a vehicle with several individuals, and there was a question as to the ownership or the possession of the firearm. So that was why I chose to make the strategic decision to put this defendant on probation. I deferred, nevertheless, with his criminal history, Judge. So that's how we arrived here. This defendant was, I say all that to say he was fortunate to get probation. I have deferred, nevertheless, Judge. He just, he did not take advantage of that opportunity, Judge, to say the least.
Well, Your Honor, if I might briefly respond, the way I read that, it was a weak case, and the prosecution didn't want to try it, and they gave him deferred, and he took it. That's how I read the
Well, okay,
situation.
yeah, I understand the issues with the underlying case. So with regard to the evidence that I heard today, on the offenses that are alleged in this motion, starting with count 1, the burglary of a vehicle. I find it, without, I guess, more information, if there were any more potentially out there, find it difficult to, obviously, he was in the wrong car, but the witness herself said that there wasn't anything in the car, it was clean, there wasn't anything for him to take, and so making that stretch, I think, for me at this point on that burglary of a vehicle would probably be a pretty big leap, and so I'm going to find count 1 not true. Count 2, with regard to reporting the arrest, I am going to find count 2 true with regard to that. I'm going to find count 3 true with regard to not completing any community service hours. Count 4, he pled true, so obviously I'll make that finding of true on count 4. Count 5, he has not even started, much less successfully completed that MRT program, so I'm going to find count 5 true. Count 6 was fees, he pled true to count 6, so I'll make a finding in count 6. I don't feel like on count 7, unless I'm missed something big, there was no evidence today with regard to the aggravated assault with a deadly weapon, so I'm going to find that not true. Count 8, what I'm going to do on count 8 is make a finding that count 8 is true with regard to evading arrest or detention, but not with the use of a vehicle. I think it's clear he was on a bicycle. I've been trying to do some research as to whether or not a bicycle is a vehicle. Something I read says yes, something does not. But there's no doubt that once he was off the bicycle, he ran with police chasing him. And at that point, I think it was no reason other than the fact that he knew he was being chased.
I actually meant to abandon the vehicle portion of that prior to getting started today, and I forgot to do
I
that.
think it's a motor vehicle, to be specific.
Yeah, I meant to abandon that motor vehicle part.
So I'm making a finding of true with regard to evading arrest or detention in count 8. And then count 9, with regard to possessing a firearm, I feel like there was really no evidence. No one saw him with a firearm when he was running or saw him toss one. I get that there was one found some days later, but I think that's insufficient even for for what I need to find, so I'm going to find count 9 not true. So what that means is we've got count 2, 3, 4, 5, 6, and 8 with regard to the lesser of evading that I have found true. Again, I reviewed that pre-sentence report. I'll hear a brief argument on punishment. Mr. Kimler?
Your Honor, just that, I think, obviously, I probably sound like a broken record on these cases, but mental health's a big issue with many probationers. I think that's the case with Mr. Guillory. Evidently at the jail, they figured out a combination of antipsychotic and antidepressant medications that seem to be working for him. If he could continue with that, while on probation, perhaps his performance would improve. So I would just make that observation that hopefully with this proper regimen with medications, that he'll be able to complete the probation.
Mr. Coleman?
I have nothing to add to my prior argument.
So we have this, and then we have that aggravated assault pending still, correct?
Yes, Judge.
Okay. What I'm inclined to do, just based on the nature of the information that I received today with the allegations of the new offenses, clearly the witness in Hardin County, even though I found that offense not true, it sounded like from the witness as well as the officer that Mr. Guillory was under the influence of something. So it sounds like there was potentially some self-medicating going on if he wasn't on the correct medication for what was going on. It's hard, his testimony is that he doesn't remember the day of the other alleged offenses, which would lead me to think that he was also under the influence potentially of some intoxicating substance to not remember anything. Because I have not found really the most serious offenses or allegations true, what I'm going to do at this time, Mr. Guillory, is again find 2, 3, 4, 5, 6, and 8. 8, obviously, with the without the vehicle allegation true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. What I am going to do is order that you enter and successfully complete the special needs SAFE-P program. I understand that you cannot do that while there's another case pending, so you guys need to talk about that other case, and if we have to wait on that, then we will. But I'm not going to just let you off probation. I'm going to make sure that you have, if that's going to be how this gets worked out, that you're going to have all the tools that you need to stay off of drugs and to remain compliant with any type of special needs mental health programs. You will be ordered to be assessed at the probation department for special needs mental health caseload. And I know you were already on the high medium caseload, which kind of gets you where you need to be. You're going to have to take advantage of whatever programs you need. You know now, you've said, I'm on medication and that makes me better. So I'm ordering that you remain on whatever it is that makes you better. And it won't be an excuse if you get off of it and you're back here in court and you have either violated the law, which obviously will get you in a lot of trouble, but even just the other things with probation that you have to do. That's not going to be excused from this point forward. We're going to give you the help you need. Does that make sense? All right, so what we'll do is I'll reset the other case, just maybe a couple of weeks, give y'all some time to visit about it, see where you are on that. If it's going to go to trial, we can get that done quickly as we can. If it's not, see what you can work out and we'll go from there. This was not a plea agreement, and so Mr. Guillory has some rights to appeal my decision. I have that. If you will come get this, Mr. Kimler, y'all sign it, give him the bottom copy. And then Mr. Coleman, I'm going to let Mr. Udishin know, he's already in Zoom, that we're going to take just 5 or 10 minutes.
Can I do it from here, Judge? So I don't have
Yes,
to
absolutely.
figure out computer
Yeah,
stuff?
and what I might do is we might just have you come stand up close so he can see and hear you better, but yeah, that would be fine.
You have your breaks, Dale, that it's fine.
Okay, here's this. All right, y'all are excused. You can take them back. And I'm gonna actually pull Mr. Yudishin in real quick and tell him what's going on.
Kelly called Kim. Did you give him his copy?
I get it.
Okay.
Tommy, I'm gonna pull them in and just let them know I need a quick break.
Set the bar for hers.
I'm gonna need that stack of, well, I'll get it. I
All
got
right,
it.
see you later.
I said, we'll see him.
How long was he at the
Just a couple weeks. Mhm. Hey, Mr. Yudishin, how are you?
Oh, hey, you, Judge.
I have felt like I've run a marathon. We've been in court since a little before 9.
All
So
right.
if you will be patient with, Mr. Coleman has been in a hearing with me as well that went just this minute. If you'll be patient and just give me about 5 minutes to go to my office, grab my notes for what we need to take care of. I don't anticipate what we're gonna do take very long, but just give me about 5 minutes to step down, take a quick break.
That's fine, Judge. No problem.
Okay, thanks. I'll be right back.
Thank you.
That would be amazing. What makes you think there's gonna be one? Because you saw the rest of the morning?
I know this lawyer right here, I'm certain there's gonna be a show.
Mr. Gertz, he can't see you on the screen. Mr. Gertz is in here, said he's gonna stay for the show because we've been having quite a show, the earliest. I feel like the show's over.
Show's over.
The show is over, right,
I saw
Mr.
the
Coleman?
old, I didn't know it wasn't my car defense work earlier today, so come on. I'm staying for the show, Judge.
I've heard it wasn't my pants.
I know.
Wasn't my call. What are you supposed to do? I mean,
I know.
I didn't know it wasn't my car.
I've literally gotten into the wrong vehicle. I'm just saying, so it's not that crazy of an argument. Somebody did get into Summer's car when she was in it. Our hearing, Mr. Yudishin, just for, just had to do with attempted or a burglary of a vehicle, and the defense that worked was he didn't know if it was, thought it was his car.
Yeah, okay.
And Ryan is very surprised at my finding that I went along with that.
I was texting Jody, I said, that never works here, you
And
know?
I was just about to text him, it worked.
Is Ms. Gilbert coming in?
She is, yeah, she's on there now, Judge.
Come on, Judge. Hi, how's it going?
Hi, sorry. Thank y'all for your patience again. We've had quite a morning.
No problem.
Okay.
Thank you for making time.
And Mr. Coleman, as soon as you've got your stuff together, if you wanted to come up here,
If I can get set up here, just
yeah,
please.
we're both moving from one thing to another, so grabbing our notes and things for this.
So if you will help me if I'm reminded of what we're hearing today, please.
We are hearing the applicant's memorandum regarding scope of the evidentiary
There
hearing,
was a supplemental file on that one.
and then also applicant's motion regarding exculpatory evidence. You're the best. Tommy, you need something to drink?
I'm fine. I'm fine.
Hot tea, water.
Thanks for asking,
He
Judge.
likes bourbon, Judge.
I do too.
Yes, I do.
We are still on YouTube. Oh, well, that's all right.
All right.
If anybody's watching YouTube, they would know why we're talking about bourbon at this point. I do have hot tea here. That's it.
You can't have hers, I'll go make you a fresh cup.
And I've read both of your,
And I
all
don't
the
have-
filings, Mr. Coleman. If
I
you
don't
want
have
to,
anything
if
to
you need
add.
to add something and find it, come on up. I think we
I
could
don't
probably
have
get
anything to
through
add, I
what,
just wanna have it in front of me, Judge, I think I'm almost there.
okay.
I got my,
And I'm sorry, we're on record and I'm calling you by your first name. I almost said good morning, Gary, too, so
All right.
I don't play favorites calling first names when it's informal. There you go. And that microphone's right up there, so they should be able to see. You can see and hear Mr. Coleman.
I can see him fine, Judge.
Okay. Perfect. All right, so we're here in 0389302-0-B Luther Garner. For the record, Mr. Udishin is joining us via Zoom. Ms. Gilbert is also via Zoom. And Mr. Coleman is here joining us in the courtroom. And this is a follow-up hearing to the hearing that we had a couple of weeks ago. At that hearing, everyone was in agreement that obviously Mr. Garner did not need to be here for these preliminary matters. Is everyone still of that opinion, Mr. Udishin?
Yes, Your Honor, we are.
Okay. All right, so we will be able to go forward then without Mr. Garner's presence. So let's start. I've gone over everything that's been filed, gone back over additionally the transcript from that hearing. And let me just tell you where I am. I have downloaded and started my reading of the original trial for Mr. Garner. I have not completed that. And because I have not completed that, I'm not going to get myself in a position to be backed in a corner making some type of finding today that specifically the hearing in April is going to cover what you've listed in your memorandum 1, 2, 3, and 4, Mr. Udishin, because I have no idea what the evidence was with regard to the medical testimony yet at that trial. I will by the time we get here to the hearing. And so my position, just like it was before, is that I think the Court of Criminal Appeals was clear in what they've asked me to do. I think I'm going to have to take into account the evidence that I read from the excerpts or the trial record, as well as any evidence that's put on by doctors, experts at the hearing with regard to your position, Mr. Coleman's position. The doctors may not have different positions. Mr. Coleman's experts may have the same opinion as yours. And that might shorten our hearing, but I'm not going to shorten and limit right now based on the fact that I don't know what was presented specifically in that case with regard to medical testimony. So I'm not going to limit the scope other than the way it is limited in the order from the Court of Criminal Appeals, which is whether or not previously unavailable medical scientific evidence contradicts the state's expert's testimony. And so I will need to hear what previously unavailable medical and scientific evidence there could have been or is at this point, how it then ties into the medical evidence that was presented in the trial. I then put that together with whether or not that would, by preponderance of the evidence, mean that the defendant would have been found potentially not guilty. And all that has to also be based on all of the other evidence that was presented in trial. And so I'd hope to have that done and read by today, just didn't happen. So I will be prepared. That's what the hearing's for, for you guys to present all that and for me to obviously find further if the state's medical experts or trial testimony, I guess, at the time was false and material, and so, which is the number 2 on that. So I really don't think it is kind of fair to me to limit myself, Mr. Udishin, to what you're asking with regard to those specific requests, because I haven't read and don't know what that testimony was, if that makes sense.
I understand, Judge, and what you're describing, I think, is the proper scope of the hearing. I don't disagree with that. I think it's become more complicated than it needs to be. Like for instance, I read the state's response to the writ application again this morning. And they make arguments that are exactly the type of arguments that I think the Court of Criminal Appeals anticipates in the remand order. They're arguing that Mr. Garner would have been convicted even without the scientific evidence. And they're arguing that some of the scientific evidence that was discussed in the Rourke case, they're arguing that doesn't apply to this case. And that's what the Court of Criminal Appeals is asking us to do. So I agree with the court on your description. I think where we get into the problem is I am unclear as to whether the state intends to, through their experts, present testimony and make an argument that the Court of Criminal Appeals opinion in Rourke concerning the new science was incorrect. And if they're not intending on doing that, then we're all on the same page.
I'm not going to, my thought, Mr. Coleman, is I'm not going to relitigate here the Court of Criminal Appeals finding in Rourke. Whatever the state of the law is at the time that we have this hearing in April, is the state of the law. And so I don't intend on, it's going to be enough for me to get prepared for the facts and the litigation in this case. I'm not going to relitigate Rourke. It's not my case. It's been decided, and the way it's been decided is the way it's been decided. If something changes later on that, then obviously this may come back again, depending on what happens in our hearing. I don't know. But Mr. Coleman, was that your intent?
Judge, far be it for me to tell the Court of Criminal Appeals that they got something wrong.
I'm not going to do it.
I do believe that in order for this court to make an appropriate determination, this court needs to have before it the science and all of the science and the literature and the studies that support the science that these experts are testifying to. Rule 702 demands that. I mean,
No, and I don't disagree.
Why would we let somebody come in here, an expert, and say, this is my opinion, without giving us the basis for the opinion? I want to make sure I flush that out completely.
I don't anticipate allowing any, quote, expert to testify about any of these issues until and unless they have been, in my opinion, the evidence is clear that they are in fact experts as to what they're going to be testifying to. So I would anticipate that that would be the beginning of each of the witnesses, that we have to go through that first. Obviously, y'all will have CVs and all the information. If there's an agreement, if you guys know each other's experts, if the experts know each other's experts, and there's anything that can be done to say, we agree that this person is an expert in this field or in that, that's great. If y'all don't agree on that, then that'll just be part of the hearing. And I'll make that finding with each witness as to whether or not I think that they can testify to what they're here to testify to. Does that make sense?
Yes, sir. I still want to be hamstrung and limited in that regard.
Mr. Udishin, does that make sense?
That judge does make sense,
Okay.
Your Honor.
Okay, perfect.
And Your Honor, one other thing regarding that, and this is more of a scheduling question. Both sides have listed, I think, 4 experts. Obviously, none of these experts live in Jefferson County, and most of them are out of state for both sides. And I'm wondering if at some point we can get some sort of schedule for presentation of the witnesses, so we don't have all these experts coming from out of state to and be waiting around for day after day to testify.
Y'all have got 3 days. You've got an all-day Monday, all-day Tuesday, and all-day Wednesday. I've canceled my dockets. Y'all don't have more than that. You only
Okay.
have that. Because Thursday's out of the realm of possibility that week. So y'all have Monday, Tuesday, Wednesday. So if you want me to say, if we've got 3 full days, Mr. Udishin, you get all day Monday and the morning of Tuesday. Mr. Coleman, you get Tuesday afternoon and all day Wednesday, and y'all got to make whatever you want fit into that time frame. Because if y'all, even at that, if I'm listening for 3 full days to all of this, my head's probably going to explode with scientific and medical stuff. So you also want to, I need the specific information, but I also probably would, for lack of a better word, say, all of the experts need to dumb it down pretty good so that I don't get bogged down in trying to become, and myself an expert on this, if that makes sense too.
That does. And Judge, that division sounds fine. I think that'll work. If a day and a half for each side.
Okay,
I'm not
perfect.
opposed to that, Judge.
Okay. So anything else with regard to the scope of that hearing?
No, I think it's resolved, Judge.
All right, and so with regard to the motion regarding exculpatory evidence, is there something, Mr. Udishin, that you think that the state is not providing, or they haven't been cooperative? I know that one kind of hit Mr. Coleman wrong, and I can see why, so.
No, Judge, I don't think that at all. The reason why I filed that motion is what's come up on a lot of these cases where we're talking about scientific evidence that we've dealt with, new science, is that sometimes we have situations where the testifying expert for the state has told the state that they no longer stand by their testimony. That's, for example. And I've been in disputes with prosecutors in other jurisdictions around the state as to whether or not that particular type of information is exculpatory and needs to be turned over to the defense. So really, the reason why I filed the motion is if that situation occurs in this case, just for a clarification as to whether or not the court and the state would agree that that's exculpatory and that should be revealed to us.
I mean, I would agree with that,
Judge,
Mr.
I
Coleman.
represent to the court that none of the expert witnesses listed have expressed any indication that they no longer stand by any opinion or opinions that they've previously rendered.
All right, and
As it
so.
relates to the subject matter of this.
And Judge, just to clarify, what Mr. Coleman said was the expert witnesses listed. I'm talking about the expert witnesses that testified at trial, and they are not listed. So I'm talking about if they have told the state that they no longer stand by what they said at trial.
And Judge, I'm not trying to intentionally be cute about this, but defense counsel, opposing counsel has at their disposal tools by which they can reach out and they can
Well, I'm not going to
conduct
require
discovery.
you to go, if they're not your experts,
I understand.
but if you have that information, if it has been in any way over the years, you have some note from the file back then or anyone that says that I do believe that could potentially be relevant for this hearing. That knowledge for myself, for Mr. Udishin, for me to make those findings of fact that the Court of Criminal Appeals is requesting. So I would order that if there is any information that you or anyone in your office has received ever from, I mean, this case is from '03. With regard to that specific question that Mr. Udishin is bringing up, that they do not stand by their testimony, then let him know that. Mr. Udishin, you know who the experts were. If y'all want to reach out and do your own inquiry, you have every right to do that. But I will order Mr. Coleman, if you know that information, to turn it over.
Judge, and I'm not quibbling with the court, I understand where the court's coming from. Just that's, in my opinion, a potential pitfall for a well-intentioned prosecutor. To not know that there is some tidbit somewhere buried in a file from 20 years ago that says,
No.
I don't stand by each and everything that I testified to.
If my guess is you and your staff have been and are going through all of this, if you find something, make that available to Mr. Yushin. That's what I'm saying. I'm not saying that, if somebody said something in person to someone that's no longer here, that, I mean, you can't know what you can't know. I get that. And so, but if there is any knowledge of anything that has to do with those experts that testified at trial, then get that information to Mr. Yushin. All right, anything else?
Nothing else, Judge. I presume we start on our hearing at 9 o'clock in the morning.
Yes, sir.
Okay.
Yep. We'll get started at 9. Typically, we'll go to 5, obviously with the lunch break. But we'll try to accommodate the witnesses the best we can, since it's not a jury and it's just us. If we need to go late to finish or something like that, or get started early on a day, I'll make myself available to make it happen within those 3 days.
Okay, then that's all we have, Judge.
All right.
Further from the stage.
Okay, perfect.
All
Thank
right.
you, and thanks for your patience this morning.
Thank you, Judge.
Thanks, Your Honor.